Goff, Executive Director of the Supreme Court Historical Society, and I'm with Clare Cushman today, who is our resident historian here at the Society. And we're going to discuss Clare's groundbreaking work, Justice William R. Day and the Origins of Supreme Court Recusal Practice. Her work was first published in an article in our Journal of Supreme Court History in 2020, entitled Sons of Ohio, William Rufus Day, Nepotism, and His Law Clerks. And it was further explored in her article in the Journal in 2021, in an article entitled Father on the Bench, Justice William Day, and Kinship Recusal. First, Clare, I want to thank you very much for all of your important work and all you do to fulfill the mission of the Supreme Court Historical Society. And my first question to you is your article on Father on the Bench, William R. Day, and Kinship Recusal draws heavily on research from the papers of Justice Day. How did you get started on this project, and give us a little background on it?
Thanks, Jim. Yeah, so I was researching early law clerks for a book that I was co-editing with Todd Peppers, and I noticed that Justice William Rufus Day had hired 3 of his sons to clerk for him. So of the 19 terms that Justice Day served, he had a son as his law clerk for 12 of them. And I thought, Nepo babies, interesting. So I headed over to the Library of Congress and went into the Day papers. And 2 years later, I emerged and I realized that I had come across a story that was even more interesting than I imagined.
Remind us, who was Justice Day and who appointed him to the court?
So Day, I think, is an underrated justice. He doesn't have a full-length biography, and we sorely need one. Briefly, he was from Canton, Ohio, where he was a trial lawyer for 25 years. He befriended William McKinley in sort of Ohio Republican political circles, and that relationship, really deep friendship, propelled him to greater heights. So McKinley eventually appointed him to be his Secretary of State, and then to the Sixth Circuit to be a judge on the Court of Appeals. But it was not McKinley who appointed Day to the Supreme Court in 1903. He served from 1903 to 1922. It was Teddy Roosevelt because, of course, McKinley was assassinated.
Mm-hmm, mm-hmm. So you started looking into clerk hiring practices and nepotism. How did you get to the topic of recusal?
Well, his sons, all 4 of them, either petitioned, briefed, or argued cases before the Supreme Court when his father was sitting on the bench. And it made me want to investigate further. I mean, did Day recuse himself? And more largely, what was the practice of recusals at that time in the early 20th century?
Was there a statute or guidelines at the time in the 19th century?
Well, not at the Supreme Court level.
Mm-hmm.
So let me just get this. Yeah, there was, in 1792, Congress passed its first recusal statute, which was amended many times in the next century, but it only applied to lower court judges.
Mm-hmm.
And it would require judges to disqualify themselves if a family member was involved in a case. It wasn't until 1948 that federal disqualification law was amended to include the Supreme Court.
So there was an informal practice of self-disqualification at the time. And we know that Stephen Field did not opt out when his brother argued important Civil War cases, such as Ex parte Milligan and Cruikshank. Would you care to describe that a bit? Yeah,
so in the 19th century, the standards were pretty lax when a family member argued or briefed a case, and it rarely triggered a recusal. The Supreme Court bar was a very close-knit group of, elite men who had had access to legal education. So it wasn't unusual for sons, brothers, brother-in-laws, nephews to present cases before the justices and on circuit as well. So think of Chief Justice Roger Taney and his brother-in-law, Francis Scott Key, who was a very prominent oral advocate. Or
People know that, by the way, about Francis Scott Key.
well, yeah, he argued in many cases. He was an appellate lawyer.
Yeah.
Yeah, as well as other things, which everyone knows. I think knows better, right? So then think also about Justice Benjamin Curtis, who was one of the two dissenters in Dred Scott, and his brother, George Ticknor Curtis, who was a Boston lawyer, argued for Dred Scott's freedom. But you mentioned Field, who is the most famous in terms of the fact that his brother, David Dudley Field, who was, again, a prominent New York lawyer, appeared many times before the court, but he argued very significant constitutional cases. And in fact, Justice Field wrote the 5-4 decision in Cummings versus Missouri in 1867, siding with his brother's client, which is really hard for us to fathom today. But this was well within the kind of institutional norms at of that time, and there wasn't really a concern about judges having a personal Supreme Court justices having personal bias.
Well, so Justice Day joined the court in 1903, and what was the read on that, the standard at that time when he joined the court?
So there was still no sort of general convention regarding recusals. It was very much up to the individual justices, as it is today. But Justice Rufus Peckham, who served from 1896 to 1909, had been opting out of cases when his brother, Wheeler Peckham, who was a New York lawyer, was bringing cases before the court. So in my research, I found that in 5 cases, Justice Peckham opted out, but he does sit for some of Wheeler's cases too. So it'd be really interesting to know what Peckham's thinking was on that, why he did it, disqualified sometimes and opted in other times. And we need someone to go through the Peckham papers and find out.
Well, my first question there is Rufus apparently was a pretty popular name at the time because Justice Day's middle name is Rufus. Then we have Rufus Peckham on the court, and Justice Day has a son named Rufus. So there you have it. Now, do you think Justice Day spoke to Justice Peckham about his reasoning on recusals?
I don't know, but I can guess because, in fact, Wheeler Peckham dies in 1905 and Day joined the court in 1903, but Wheeler had already argued his last case before Day arrived. So I don't think Justice Day would have seen sort of in real time his brother and Peckham wrestling with this issue of, oh, my brother's coming. Should I sit out or should I sit in? But they both had served as judges on appellate courts before being appointed to the Supreme Court. So they had been subject to recusal legislation. So I think that they probably had a similar sensibility anyway that maybe influenced their behavior. It'd be really interesting to know if when Day's sons came before the court, if Peckham gave him any advice.
What about other justices at that time?
Well, so the main justice that I've sort of looked into is, of course, John Marshall Harlan, because he had 2 sons who were active in the Supreme Court bar. Harlan never sat out. He had been on the court since 1877, and he sat, with Stephen Field for 20 years. So I think Harlan had more one foot in the 19th century in terms of his thinking in that regard. Also, Harlan hadn't sat on an appellate court before coming to the Supreme Court. But in terms of the other justices, Holmes didn't have any children, but we need scholars to look into that too.
Do you think that Day was more like Peckham or more like Harlan in this regard?
Well, he was definitely more like Peckham. He often recused himself when his sons brought cases, but he was very close to Harlan, and they were really good friends. In fact, they lived in the same neighborhood, and I think they walked to the court or they took the streetcar together often. But they also have a similarity because the only 2 justices who had sons who they hired to be their own law clerks at the Supreme Court. Or I should say, Harlan hired his first son, John Maynard Harlan, to be his clerk, and then he got Chief Justice Fuller to hire his second son, James. And then both of these Harlan boys went on and had very illustrious legal careers in Chicago, and they came to the court to argue or brief 12 cases. And as I said, Harlan didn't sit out. He also didn't sit out when his law partner, his nephew, argued cases, so he was not as concerned about the optics of that than I think Day. We'll hear about Day, but that Day did.
Yeah, tell us some more about Day's sons. Who was the first one to present at the court?
Well, so Day had 4 sons, and they were all, I think, handsome and athletic. Their names were William, Luther, Stephen, and Rufus.
Of course there's a Rufus.
Yes. And they all grew up in Canton, Ohio, and I think they had a charmed childhood. It was a very happy family. The boys all played sports, baseball, football, tennis, golf. They summered on Mackinac Island. It was a really happy family, as I said. So the first son to present a case was Stephen. He was actually the 3rd son to clerk for Justice Day, and then he also clerked for Chief Justice Fuller for a year. And then Stephen goes on to Chicago to become a lawyer. So he was on the brief in a 1911 case, which was on appeal from the Seventh Circuit, and Day chose to participate. It was not until Luther, the second son, who actually argued a case in 1917 that Day recused himself for the first time, presumably because a son was involved.
What about Day's oldest son, William? Can you tell us about him? And there's an anecdote about Oliver Wendell Holmes involving him.
Yes. So William, the oldest son, was apparently a spectacular athlete at University of Michigan, and he was called Big Will. And I'm going to interrupt you just for a second. Yeah.
He predates Willie Stargell, who was known as Big Will with the Pittsburgh Pirates many years later.
Yeah, I think he was in college in like the 1905 era. But he was big. And what's so interesting about this is, well, let me just say a couple things about William. So he was the only Day brother not to clerk for his father. So there were 3 out of 4, not William. And then he became a district judge after being at University of Michigan. And then he moved to Cleveland and developed, again, a very successful private practice. But the story you're alluding to is the famous one where William comes to the bench to make his first oral argument in 1916. And William is over 6 foot tall. Justice Day, his father, who's facing him on the bench, is 5'6", but he's actually very slight and frail. He was pretty sickly. I think he must have had some autoimmune issues, but he had pneumonia, the flu quite often. He missed several terms on the bench, so he was a small guy. Anyway, the fun story is that Oliver Wendell Holmes passes Justice Day a note on the bench, and he quips, "Your son is a block off the old chip."
It's a very clever line.
Yeah, love Holmes. He always has a good one. But so Day did not recuse himself in that case. He wouldn't. That was 1916. He didn't recuse himself until 1917, as I mentioned, when Luther argued a case. So let me just talk a little bit about Luther, because he's going to figure pretty importantly in this story. Luther was Day's first law clerk, 1903-1904. He had actually clerked for Day when he was an appellate judge, and then Day brought him to the Supreme Court with him. And Luther, like William, eventually ends up in Cleveland, where clients hire him to take appeals from the Sixth Circuit to the Supreme Court. So in 1917, he argues on behalf of a steamship company accused of negligence by an injured employee. And the court, for the first time, officially notes, for the first time with Day, that Justice Day, quote, took no part in the consideration of the decision of this case. And that's how we know that Day recused. It's public. It's made public. And then the following term, Luther argues another case, and he represents a newspaper being sued for copyright violation by an illustrator. And again, Justice Day recuses, and Luther actually lost that case. So there were real consequences to having his father sit out.
Well, I have to hear more about Rufus, the fourth son.
Yeah. So Rufus was the fourth son, and he was something of a problem child, or I should say he was immature. We have to back up a little bit and talk about the Day family in general, because there were many illustrious judges and lawyers in the Day family, and it was very clear that Justice Day wanted all four of his boys to enter the legal profession. As I said, Luther and Stephen had clerked for their father. They had read law in the Canton law firm that Justice Day had been part of, and now his brother William supervised them, or their apprenticeship there. So law was the family business, and they really all helped each other. The brothers helped each other, the father, the uncle, they helped each other to succeed. So when Stephen moves on from clerking for his father, there was no question that Rufus would have to be the next law clerk for his dad. The problem is that Rufus was not really quite ready. He was 22, and he had been, shall we say, an unmotivated student. And he was a little lax with his studies. I've read a lot of the correspondence between the headmaster of his school. He switched schools twice in high school, and he never finished college. But the real problem for Rufus was actually learning the shorthand. And as you know, in those days, the law clerks for justices were, they were really secretarial or clerical workers, and learning how to do stenography was really important in the days before word processing. So one of the fun things in the day papers is reading the letters between Luther and William and Rufus and Stephen about how do we get Rufus up to speed so that he can be a proper law clerk for our dad. And in fact, Rufus didn't quite make it. He didn't quite apply himself. And so Justice Day went for a whole term without having a law clerk. But in the end, Rufus did clerk for his father for 4 years, and he and his wife, Madge, moved in with Justice Day and his wife, Mary, to their house on Clifton Street, which is sort of up near Howard University. And then after 4 years, Justice Day has run out of sons, and he hires sort of a professional stenographer. But the story doesn't end there, so you have to bear with me, Jim, because I've got to get this all out, because it's hard to believe the twists and turns that happens with Rufus. So, in 1912, tragically, their mother, Mrs. Day, dies of spinal cancer. She's 61. And so Rufus and Madge, who have gone back to Ohio, for him to be back in private practice after leaving the clerkship, dutifully come back to Washington, and they move back into the home to keep Justice Day company, which I think tells you how tight-knit that family really was. And then Rufus develops a legal practice in Washington, which brings us back to the subject of recusals, because Rufus practiced appellate law. But the story actually continues, and let me just finish one more thing with Rufus, because he has two interesting components to him, both the clerkship sort of nepotism, but also the recusal. So in 1917, Justice Day's law clerk, the sort of professional stenographer, quits abruptly in a huff. And it's right when the U.S. has entered World War I and men are being conscripted. So there's a lot of pressure on Rufus to step in again to be his father's law clerk because of this sort of labor shortage. So he does. He comes back again, and he stays until his father's death in 1922. So Rufus clerked for his father for a total of 9 years in 2 different stints. But when he comes back for the second stint, this is the important thing about recusals, is that he says, I will come back and clerk for you under the condition that I be allowed to continue to practice law, including appellate law before the court.
Did the press take note of this at all during that time frame?
Not that I could find. I didn't find any mentions of it.
Was he actually presenting cases to the Supreme Court too at the same time? No.
He does. I mean, it's all public. Rufus takes out ads in Martindale Hubble and law directories advertising his services. I'm in the quote. It says, from one of his ads, it says, practices before the federal courts, executive departments, and the federal commissions. I mean, he doesn't mention that his father's sitting on the Supreme Court or that he's clerking for his father.
Yeah. Was Justice Day concerned about nepotism when he hired his sons as clerks?
Well, that's an interesting question. I mean, I think we have to first address whether, they were qualified. So it's very clear that both Stephen and Luther were qualified. They had, good educations. They'd studied law. They'd apprenticed in law firm. Rufus probably would not have been hired by another justice. I mean, as I said, he didn't actually have a high school diploma. He didn't have any law school.
High school or college?
He didn't finish high school.
Wow.
Yeah.
Okay.
Yeah. He didn't have law school experience. But in terms of Day's concerns about nepotism, yes, he was concerned. And this is what's really interesting. This is actually in my first article about nepotism. He sought the views of another justice when he was going to hire Stephen. Remember, Stephen was his second law clerk. This is in 1905. He wants to hire Stephen to succeed Luther, who had clerked for him for the first 2 terms. So he asked David Brewer, who was the senior associate justice on the court. And in Brewer's response, we have the letter. To Justice Day, he cites relevant congressional statutes barring the employment by a judge on any court of a family member, quote, within the degree of first cousin. But in this really extraordinary letter by Brewer, which is really worth reading, Brewer says that Supreme Court law clerks, in his view, should be exempted because they're actually only private secretaries, which means that they work directly for the justice out of his home. They don't have any interface with the public or contact with the public, and they do not take an oath of office. And so while all this is true, Brewer does acknowledge in this letter today that the optics maybe aren't that great. And he says if anyone ever challenges Day for hiring his son, he can present this letter from Brewer to show that he actually had sought advice on this matter.
You mentioned works with the justice out of his home. And in those days, there wasn't the Supreme Court buildings. That was not unusual for them to work out of the home. Is that
yeah, there were no chambers in the Capitol building for the justices. So their law clerks were. I mean, they called them private secretaries. They were, and the work was clerical. But yes, they were at home all day with the justice. In Rufus and his brother's case, they also, spent the night there and took meals with them. It was a very intimate relationship in some cases.
Well, Rufus had a very busy life at that point in time, practicing law and working as secretary of law clerk for his father. How did he manage to do that?
And he had a wife and two children. Yeah. Well, it's an interesting question. So I've thought a lot about this, about what Rufus's life would have looked like. And I do have 2 points about your question about time management. And one is that, as we said, the job of a clerk in that era was really clerical. I mean, they did stenography, proofreading, typing, errand running, chauffeuring, bill paying. It was more of that than it was, writing bench memos, or even summarizing cert petitions. Most of the clerks in that era, with the exception of Holmes and some of the other justices, had a more modern clerkship model, but most of them didn't. And Day didn't. So
Day did not, you say?
I don't think so.
Right.
I mean, I really tried to figure out exactly what the Rufus was doing or the other sons. And from the correspondence, it really seems like a lot of stenography and typing and proofreading. And I didn't see anything that involved cert summaries. But, things can be missing from the papers.
Yeah.
But my other point about Rufus is that, so he has this big legal practice, including, appellate practice. I'm not really sure if he was always when he was on the briefs in a case. I'm not really sure how much work he actually did. And that's because I think he might have filed motions at the court on behalf of attorneys, out-of-state attorneys. Most of his clients were in Ohio, including his two brothers who are now in private practice together, and they're sending him appellate work. But he might not have actually really written the briefs because, as you know, in that era at the court, there had to be a local D.C. attorney because it was unpredictable when the court would schedule a case. And so the court only notified the Washington attorney, whose name would have been on the briefs, about when the case was happening. So Rufus could have been more of a symbolic partner on some of these cases. It's hard to know.
Well, as we're going to discover in our next podcast about the kinds of cases the court was considering in those days, it was very different from what evolved just a decade or two later after the Judiciary Act of 1925. So the kinds of matters they were, you mentioned about bench memos, cert memos, things like that, really were not all that common at the time that his sons were serving in that capacity. Did Justice Day recuse himself from any of the cases that Rufus, if Rufus, first of all, I guess, did Rufus argue any cases before the court? And if so, did Justice Day recuse?
Yes. So as I mentioned, he had started recusing in 1917 with Luther's case. And when Rufus argued, Day often recused, not every time. As I said, most of his cases were from Ohio, but Rufus did co-argue a very high-profile case from New York. He represented a professional gambler and con artist who was the husband of comedian Fanny Brice, and Day recused. The court found in favor of Rufus's client. So there were some high-profile cases that Day, was careful to opt out of.
Did the Day brothers continue to practice before the Supreme Court after Justice Day retires and then passes shortly thereafter?
Yeah, so after 1922, Luther, William, and Rufus all together had a successful law firm in Cleveland. It was called Day and Day, and it eventually merged with other law firms, and it is now Jones Day. William died of a heart attack in 1936, but Luther and Rufus worked at the firm well into their 70s. And I love this. They both retired together on the same day in 1957, which shows, again, the close bond between the two brothers. I have to say that Luther was particularly considered a brilliant lawyer in the Ohio bar. He was revered for his talent, but also his ethical standards.
Oh. And Jones Day, to this day, his practices before the Supreme Court. In many cases, they have quite a stable of practitioners there in the firm that specialize in it.
Yeah, of the caliber of Luther. Yeah.
Yes.
Yeah.
Why do you think Day recused himself in some cases, but not others?
It's really hard to know. I mean, absent a letter or a diary explaining his motivations, I did count that Day disqualified himself in 9 instances when one of his sons briefed or argued a case, which we know because the recusal is stated publicly in the court record. So in general, though, I think the aim of a judge is to recuse in order to ensure an impartial, that he or she is an impartial decision maker for both parties, and also to protect the integrity of the judicial system. But at the Supreme Court level, as you know, recusal means introducing the possibility of a 4-4 vote, which would be a stalemate. And because the justices can't just, call on other justices to replace them. In practice, looking at Day in particular, I didn't find that any of his recusals resulted in a tie. But he would have recused before the tentative vote was taken in conference anyway. Anyway, we do have to be careful, though, when we speak about judicial propriety at the court level, because there is a strong incentive for the justices to sit in on cases to give both parties the benefit of a full bench.
Full court, right. Let's talk about the son's ethical responsibilities, too. Do you think they had any particular responsibilities in that era? Again, times have changed and ethics codes have changed and evolved since those days. But what about at the time?
Yeah, most definitely. They had their own ethical considerations. The ABA passed a canon of ethics that was ratified in most states in 1914, and that required lawyers to disclose to their clients any relations or connections in a case, which means that the Day brothers should have told their clients that their father was on the Supreme Court bench if the clients didn't already know that. It's interesting, though, to think, do you think the clients would have thought that was a plus to have their father be on the bench, or would they be worried about a possibility of disqualification and then an even split? I do have to keep saying that the Day brothers were really considered top attorneys in Ohio. They were very talented and admired. So I would think that the clients were hiring them as really for their talent.
What about Rufus at the time? Do you think he violated any ethics laws living at home with his father?
Most definitely. So Rufus has a separate ethical challenge because he's clerking and serving, preparing cases for his own clients that his father will then be reviewing on the court. So Rufus, as I said, lived with his father. They took meals together. It's just really hard to imagine that Rufus did not violate the clause in the ABA Canon of Ethics that requires that attorneys maintain their independence from a judge by not communicating with the judge about a pending case. So even if Rufus was careful, he didn't lobby his father to, on behalf of his clients, just the very nature of their relationship and their proximity would have been a violation, I think, of that code of ethics. And I do think that Rufus should have chosen to give up his law practice if he wanted to be a law clerk or vice versa. But again, this goes back to Brewer's letter that I was mentioning before, and this notion that Supreme Court law clerks were private secretaries doing clerical work. And so it's true that in those days, as you said, the clerks didn't really feel that they were working at or for the Supreme Court. They were at home with the justice. Some of the justices paid their clerks out of their own pocket to supplement their salaries because they were pretty meager. But all of the clerks were government employees who were receiving a salary from the U.S. Treasury, including Rufus. So whether he or his father didn't feel that they were, Supreme Court employees, they were federal government employees.
But wasn't at the time, didn't a lot of government attorneys augment their salaries by engaging in some private practice of law as well? And was that, I believe that was the case, or was it changing around that time, or still part of the routine practice?
Yeah, so it had been the longtime practice for government attorneys to augment or supplement their salaries by taking on private clients, and that was perfectly acceptable. I did find a letter written in 1924 by the Attorney General, Harry Doherty, and he is successfully advocating to increase the salaries for government lawyers, but what I found interesting about this is that he's not saying we need to augment their salaries or increase their salaries to avoid conflict of interest by having private clients. He's saying government attorneys now are working longer hours and they no longer have the time to take on private clients. But this made me realize that, I mean, if you think about this perspective, that maybe that's what Justice Day was thinking. And he was thinking, I don't want Rufus to have to give up a lucrative law practice to continue being my clerk and drawing a very modest salary to be my clerk.
Mm-hmm. Did the recusal practice at the court change or evolve after Justice Day's passing?
So, yes, in 1925, a couple years after Day leaves the court, Susan Brandeis, who is the daughter of Justice Louis Brandeis, actually, it's Susan Margolin is her name. She argued a case on appeal from the Second Circuit that involved a veteran's insurance claim. And the case made big news headlines, probably because it was the first daughter of a justice, and that was a huge novelty. And Brandeis sits out, he opts out. One of the newspapers said, quote, out of delicacy, which I liked. So clearly the norms were changing and, judicial propriety was a bigger consideration. Chief Justice Taft also had an issue with his brother, Henry, who was a New York lawyer. And Henry was of counsel on several cases, and Taft did opt out, but not consistently. I found a couple of times when Henry was of counsel that Taft sat. So again, the norms were changing, but there wasn't a consistent bright line. It was left up to the individual justice, and then even with individual justices, it was very much sort of case dependent, I would say.
Well, your research has been very enlightening, Claire, and we're so pleased and proud of it. Published it in our journal. And in conclusion today, how would you sum up the development of the recusal practice in the first decades of the 20th century? And do you think the justices became more concerned, both in optics and propriety, since that time?
Yeah, so looking at the examples we've looked at Peckham, Day, Brandeis, Taft, and we do see a development of an institutional norm towards worrying more about propriety or conflict of interest, avoiding conflict of interest. There was more scrutiny by the press on the court by that time. Also, I think the Supreme Court justices were sensitive to this sort of larger trend of professionalization of the legal establishment, the codification of legal ethics. But I also found a letter from Willis Van Devanter, who had joined the court in 1911, so who had sat with Day for 10 terms. And he has been asked by Charles Evans Hughes about sort of what's going on with recusal at the court. And I just want to read the letter because it does a better job than I could in sort of summing up what was happening. So this is Willis Van Devanter writing to Charles Evans Hughes in 1933. He says, formerly it was the general practice of members of the court to sit in such cases. He's talking about cases where a family member is involved. But the practice has gradually undergone a change so that now a member of the court seldom, if ever, sits in a case where a near kinsman, such as a brother or a son, participates in the presentation of the case, either by oral argument or printed brief. The change here mentioned was brought about not by any action of the court, but by the individual action of the justice particularly concerned.
Well, thank you very much, Claire. This has been a enlightening and interesting and fun conversation.
Thank you, Jim.
Thank you.
Happy to be here.